Representative Holt for closing comments on HJR 5.
Thank you, Mr. Speaker, and thank you to everyone for the discussion we've had this evening. We'll go through some of the points that were made before I go to my closing comments. Representative Anderson, it was actually the Iowa Supreme Court that amended the Iowa Constitution by judicial fiat. We are attempting to return it to neutrality on abortion by following the proper procedure to amend the Constitution. And I don't know why we would fear the people's decision in this regard. Representative Donahue, I am pro-life, and I make no apology for it. When I think about abortion, I think about two hearts and two souls. I am pro-life, and I will make no apology for it. And I would like to say that I have an expectation that this could get us to the heartbeat bill or get us to something that we fought for on the issue of abortion, but I have no such expectation. My hope is that the amendment, if passed by the people, would protect the reasonable restrictions we have on the books, such as our 20-week ban on abortion or the ban on taxpayer-funded abortion. And those things are in jeopardy. They are in jeopardy because we have two Supreme Court justices, Mansfield and Waterman, who stated in their minority opinion, and I quote, "I wonder if the majority is laying groundwork, instead perhaps a stepping stone, toward a ruling that Iowa's Medicaid program must fund abortions." They went on to say, "The majority requirement of strict scrutiny and narrow tailoring combined with this rejection of Casey's undue burden standard would make any abortion restriction very difficult to sustain," unquote. So I'm not going to stand up here and say as a pro-life individual, I supported the heartbeat bill. I am pro-life. I have lots of quotes here from embryologists who say that life begins at conception. That's scientists. But I have no expectation that this amendment would accomplish that. Representative Brown Powers, no one said that rape and incest and all of the other things you mentioned don't matter. We said that they were not impacted by this amendment because we don't believe that they are. And you want to talk about convenient constitutional rights. Considering you give no consideration to the second life involved in abortion, the right to life for that unborn child. That body is never mentioned by those who argue in favor of abortion. And Representative Brown Powers, we can do more than one thing at a time in the Iowa House and the Iowa Senate. There's 100 of us. There's lots of committees. We can do this and a lot of other things at the same time. Representative Steckman, we have advanced numerous initiatives to foster adoption. We doubled the adoption tax credit a couple years ago, and we just had a subcommittee today to double the adoption tax credit again. And there have been other initiatives like that as well. Representative Russell Kershell, on protecting mothers and birth control, again, not that those things aren't important, but we don't believe those are needed because we don't believe the amendment touches those things. And again, you never talk about the other body in abortion. Now, Representative Russell Kershell, let's talk a little bit about being misled, and let's talk a little bit about truth over lies. I like that. So let's talk a little bit about truth over lies. Who's fooling whom when 7 states, and maybe it's 9 now, but at least 7 states, Alaska, Colorado, New Hampshire, New Jersey, New Mexico, Oregon, and Vermont now allow abortion at any time for any reason, even up to the day of a baby's birth. Who's fooling whom? People on the floor tonight kept saying that's not a thing, that's not real, that's not going to happen. 7 states currently allow abortion up until a baby's birth. And let's face it, folks, the only difference between a child unborn and a child born at 9 months is location. Who's fooling whom? When taxpayers in 14 states, Alaska, Arizona, California, Connecticut, Illinois, Indiana, Massachusetts, Minnesota, Montana, New Jersey, New Mexico, Oregon, Vermont, and West Virginia have been required to fund elective abortions. And the Hyde Amendment on the federal level did nothing to stop it. And who's fooling whom? When the Democrat Party's national platform calls for taxpayer funding of abortion. So yeah, let's talk about truth over lies. Representative Masher, again, as I said earlier, we can do more than one thing at a time in the Iowa House, and there are two bodies involved in abortion. Representative Bohannon, I just want to say to you, I have respected and appreciated some of the perspective that you've given on judiciary and in subcommittees, and I am certainly hopeful we can disagree on issues and still forge friendships across the aisle in this chamber. I know I certainly have friendships with members of this chamber, and I hope to have one with you as well. Obviously, I don't agree with your conclusions on history or conclusions of what this amendment would do. But you mentioned quickening, and you talked about when that took place. And again, I'm hoping that our reasonable restrictions on abortion, such as our 20-week ban, would be allowed to stand if this amendment passes the people's vote. I have no illusions that it will end abortion in Iowa. And again, I just think you talked about irony. I think there's a lot of irony here when we talk about rights, but we never talk about the rights of the unborn child. I don't get that. Now, I wanted to talk a little bit about some points that Representative Bohannon and Representative Russell Kershell made about, let's face it, the United States Supreme Court has changed, and perhaps Roe v. Wade could be changed, and in some way the courts could return, let's say, what happens on abortion to the state level. And I don't normally respond to hypotheticals, but in this case, I think this is a good point to respond to. So this amendment doesn't outlaw abortion in Iowa, but let us say that somehow the federal court returned the right to decide on abortion issues to the states. I would just offer this perspective. Who should then determine how abortions are dealt with in Iowa? Should it be unelected Supreme Court justices? Because right now we have a constructionist court, an originalist court. Some would say conservative. Prior, with Justice Cady, we had a court that tended to be more activist in nature. So, on both sides of the aisle, should it be returned to the states? Who are we more comfortable with having to decide issues of abortion? A Supreme Court that could be conservative or liberal, if you want to use those terms, or the people of Iowa through their elected representatives? I pick the people of Iowa. Somebody mentioned that abortion would be unconstitutional in Iowa if this amendment was to pass. I would point out that is not accurate because Tennessee followed almost exactly the path we did, and of course abortion continues to remain legal in Tennessee. Their Supreme Court some years ago created a right to abortion in their Constitution, following a path not unlike Iowa's path to amend the Constitution. The Tennessee legislature passed it through 2 general assemblies. The people voted on it. It was challenged before the U.S. Supreme Court. The U.S. Supreme Court refused to hear it. It is now the law in Tennessee, and abortions continue in Tennessee. So I think, if you want to talk about truth over lies, I will say again, I have no illusion or expectation, and I am pro-life, and I make no apology for it. I believe there are 2 heartbeats involved, 2 souls when it comes to abortion, and we always forget one of them. But I have no illusions that this amendment is going to do some of the things that were suggested tonight. So I believe that House Joint Resolution 5 is needed because the people of Iowa and not unelected judges of the Iowa Supreme Court should decide how Iowa regulates abortion. U.S. Supreme Court Justice Neil Gorsuch, in a rare interview given not too long ago, made observations that I think are pertinent to this discussion. He said, quote, "I want an enduring constitution, and the idea of originalism is just simply that judges should follow the original meaning of the words on the page and neither add things that aren't there nor take away things that are there. And I worry that both of those things happen when we depart from the original meaning of the Constitution." Justice Gorsuch then pointed to the Dred Scott decision as an example of the danger of judicial activism and adding things to the Constitution that are not there. He said, quote, "The first time the Supreme Court really departed from the original meaning of the Constitution was perhaps Dred Scott, when the court found a right for white persons to own black persons as slaves in the territories of the United States," unquote. He then added, "Scour the document as long as you want, you will not find that right there. They made it up." And boy, did they ever make that up, because it ain't in our Constitution. So the courts don't always get it right, let's face it. So similarly, I believe that the Iowa Supreme Court made it up when they found a fundamental right to abortion in the Iowa Constitution. And contrast the reasoning of the Iowa Supreme Court a few years ago when they created this right with the concept of originalism that Justice Gorsuch discussed. When the Iowa Supreme Court struck down our 72-hour waiting period, the majority opinion stated that we had, quote, "freed ourselves from the private views of the Constitution's founders," unquote. The opinion went on to state that the Constitution should instead be interpreted by the, quote, "current prevailing standards that mark the progress of a maturing society," unquote. Now, the judicial reasoning stated in this ruling, creating a fundamental right to abortion when none had previously existed in the Constitution of Iowa, is the exact opposite of the reasoning stated by Justice Gorsuch in how the courts should read and decide cases. And it goes right to the heart of his fears of what might happen to our Constitution if things are added or taken away from the words that are actually in our Constitution. And I share his concerns. I believe the people of Iowa, and not unelected judges of the Iowa Supreme Court, should decide how Iowa regulates abortion. And if the prevailing standards of a maturing society truly are the prevailing standards, then surely they would be reflected in the makeup and decisions of the legislature and would not need to be mandated by an activist Supreme Court stepping outside its constitutional bounds. The implications of this ruling, therefore, go far beyond abortion. This ruling challenges the very way our state government functions. It challenges the legislature's constitutional role in government to make laws. And it challenges how the Constitution is supposed to be amended in the state of Iowa. If the Iowa Supreme Court is the final arbiter in determining what should be added to the Constitution, as well as what laws should be struck down that we, the elected representatives, have passed, and they base their rulings not on what is written in the Constitution, but instead upon their unique view of what constitutes the current prevailing standards of our society, then those of us serving in this chamber and over in the Senate, we ought to just take our pens and papers and go home, because, folks, we just became irrelevant. The legislature makes laws, the courts interpret, but not under the philosophy expressed in the ruling that struck down our 72-hour waiting period. This is the first reason that we need the Life Amendment, to respond to the challenge to legislative authority and the people's authority that is expressed by the majority opinion that struck down our 72-hour waiting period and ultimately led to a lower court striking down our heartbeat protections. Again, I believe the people of Iowa and not unelected judges of the Iowa Supreme Court should decide how Iowa regulates abortion. The second reason I believe we must have the Life Amendment is that without it, as I've talked about earlier, I believe we are likely on the way to late-term and taxpayer-funded abortion in Iowa. The ruling striking down our 72-hour waiting period, which led to a lower court striking down our heartbeat protections, created a fundamental right to abortion subject to strict scrutiny in Iowa. Not undue burden, but strict scrutiny. Under this ruling and its application, none of our protections are likely to stand against court challenges. Our 20-week ban on abortion, our laws preventing taxpayer-funded abortions could all succumb to this ruling based upon the strict scrutiny standard that now exists. And again, don't take my word for it. Supreme Court Justices Mansfield and Waterman, in their minority opinion, made this clear. I will quote them again. "I wonder if the majority is laying groundwork, instead perhaps a stepping stone toward a ruling that Iowa's Medicaid program must fund abortions. The majority requirement of strict scrutiny and narrow tailoring, combined with this rejection of Casey's undue burden standard, would make any abortion restriction very difficult to sustain," unquote. This is not fear-mongering, has been said at times, but rather the measured opinions of two Iowa Supreme Court justices in the minority opinion of Planned Parenthood versus Reynolds. During the debate, folks have stated that late-term abortion just is not a thing. It just isn't a thing. Well, as I stated earlier, 7 states, and I think the number might now be 9, allow abortion up until birth. So let us be realistic. The only difference, as we've talked about before, between a baby born and a baby unborn is location. The strict scrutiny standard could very well result in Iowa's ban on abortion after 20 weeks being struck down. And taxpayer-funded abortion is also a real thing. As I discussed earlier, 14 states currently require taxpayer funding for elective abortions. The proposed amendment before us would not stop one abortion in Iowa, contrary to some of the things that have been said tonight. It would put the Iowa Constitution right back where it was prior to the ruling that created a fundamental right to abortion in the Constitution. The right to abortion will rest where it always has in Iowa, with federal rulings and federal law. So we need this amendment because the people of Iowa and not unelected judges of the Iowa Supreme Court should decide how Iowa regulates abortion. We need this amendment because without it, we could see taxpayer-funded and late-term abortion in Iowa. Many Iowans instinctively know that what is growing in the mother's womb is a baby. But now a handful of unelected judges have created a precedent in Iowa that could lead to making it legal to kill a baby up until birth and making Iowans pay for it. Many who are pro-choice do not support this extreme position on abortion. So once again, the amendment reads, to defend and protect unborn children, we the people of the state of Iowa declare this Constitution does not recognize, grant, or secure a right to abortion or require the public funding of abortion. Mr. Speaker, I move House Joint Resolution 5.